I'd like to call to order this meeting of the Legal Affairs Committee of the City Council of the City of Peabody. Present here for the committee tonight, our councilors Gould, Melville, O'Neill, and sitting in for Councilor Gravel, Councilor Rosignol, is that okay? Councilor Rosignol, also present. We have Councilors Turco, Charis, and Sasslaw. Thank you for being here. The first matter before us tonight is item A, request to purchase city-owned land, 0 Birch Street, also known as 82 Birch Street. On this issue, we have a communication from City Solicitor Buckley, which clarifies the point that this committee asked for clarification on with respect to the city's true ownership of the property. We wanted to clarify that we actually had clear title to the property before we decided to sell something. My belief is that this provides black and white proof that the city does own the property. I'd be open to comments from any of the committee members or other councilors that might have comments on the communication from the city solicitor. Councilor O'Neill.
Thank you, Chairman McGinn. Yeah, I went through the package too, and it was nice that we had confirmation that the parcel is in the property properly of the city. And based on what I've seen and the small nature of the parcel, I'd recommend that we act favorably to sell the city-owned parcel known as 0 Birch Street. And I don't know if any other councilors wanted to comment on it, but maybe I'll wait for that and then make a motion.
Comments from other councilors? Councilor Manning Martin.
Thank you, Mr. Chairman.
I'm sorry, I'm going to go to the committee first. Councilor Gould. Okay, he's deferring to you. Councilor Manning Martin. We have excessive politeness tonight. Councilor Gould.
Thank you. Thank you, Councilor Manning Martin. Mr. Chairman, this is Ward 6, Councilor?
Through Chairman McGinn, yeah, it's Ward 6. It's a piece of property that originally, when the land was developed, the developer did not put this piece of parcel through, there's a whole lineage of things that didn't go on. It didn't get part of the deed, so it's just kind of been landlocked there. And then through a tax delinquency quite a few years ago, the city took ownership of it. So it is not small enough to develop or build, and that was my concern, that it would be something else in a residential area, but it's a small piece of parcel, and there is some interest from abutting neighbors who would want to possibly split it up or whatnot, but that's something to be considered later on.
Thank you. Through you to Councilor O'Neill. That's what I was looking for, because we sit here and there's all kinds of parcels all across the city that we're really not sure how large or how small or what their makeup is, and if you feel comfortable with that, I'm in support of that. Thank you, Councilor. Thank you, Mr. Chairman.
Thank you, Councilor Gould. Councilor Manning Martin.
Thank you, Mr. Chairman. So this is this an act in response to neighbors wishing to purchase it? Are there more than two? There's more than one that wish to divide it up?
That I don't know if that question was. You seem to be looking at Councilor O'Neill, but
and he's waving. So yes.
Okay.
Through you to Councilor O'Neill, the Ward 6 councilor in which the parcel exists. Thank you.
Thank you, Mr. Chairman. No, I was waving. I was just trying to say there was two. This came up because two neighboring abutters, if you will, of the parcel applied for the purchase. This was back in May, and that's how this process started. So, thank you.
Thank you very much, Councilor O'Neill.
Any other councilors? Seeing none. Councilor O'Neill.
Thank you, Chairman. Mr. Chairman, I'd recommend that the sale of this parcel be referred to the city clerk's office. The notice of butters, I'd recommend that we act favorably to sell this parcel known as 0 Birch Street, and move that the sale of this parcel be referred to the city clerk's office to notice of butters in the event that there is any interested parties in the purchase of this parcel. I would also request that Community Development Department issue an RFP and arbitrate the sale if there are more than one interested parties. So moved.
Councilors, you heard the motion. On the motion, hearing none, roll call.
Councilors Melville,
Yes.
O'Neill,
Yes.
Rozignol, Gould,
Yes.
McGinn.
Yes.
Motion carries 5-0.
The second matter that's before us this evening is Chapter 40, Section 57, local licenses and permits, denial, revocation, or suspension for failure to pay municipal taxes or charges. Councilor Rozignol, we're in a fresh topic, and we've Councilor Gravel's here now.
I'll
so
yield.
Thank you. So the second matter that I just read is a matter that was referred to this committee by Councilor Manning Martin, so I want to allow her an opportunity to speak on this first. Councilor Manning Martin?
Thank you, Mr. Chairman. Yes, this issue came to light several months ago when the tax collector had written a note on, an informational note on a special permit that came before us, that there were back taxes on the petitioner. And so after inquiring on that, there was a change in the law in 2016, and I did see Mary Martin here. I was hoping that the collector or the auditor who could speak to this, or the city solicitor could speak to it, but I don't see anyone here. I know Mary is here, and I know she's well-versed on it. But as it was explained to me that there was a change in the law in maybe 2016 where it used to be, and is as in our policies and ordinance, is that the collector could only annually notify us of that information, and then only then could the council take any action. So in 2016, evidently it changed, and the best I could see was the only thing that changed is they added the word periodically, so that we could receive that information periodically and therefore act upon it if we should choose to, instead of being restricted to an annual review and an annual time to take any action. So the law had changed, and I was told that we would have to enact this and then in order to use it. And I think it's very useful and another tool for the council to be able to incentivize businesses or residents, should they fall into that category as well. But it would be to the discretion of the city council when it came before us, and again, to incentivize folks to pay their taxes in a timely fashion instead of getting in $70,000, $80,000 in arrears. So for discussion, that's the backstory.
Yeah, just Councilor Manning Martin, on your backstory, I did check this with the clerk and with the Director of Finance, and I would concur with your assessment that the only change is the elimination of the 12-month waiting period. Other than that, it's precisely what is on the books today. So it is a relatively simple matter for us to make this adjustment. I would agree, but it will require an action of the council. Mr. Morphus, you want to take on this topic?
What's the question? I'm sorry.
I'm not sure. Did you hear the summary from Council Manning Martin in terms of what you did not? Okay. Just to summarize, we have a section of our code 16-4 that is consistent with Mass General Law, Chapter 40, Section 57, except that it does not include the most recent changes to
Yeah,
that law,
yeah.
which both Councilor Manning Martin and myself are of the belief that the only difference is the elimination of a 12-month waiting period. Are you also?
Correct, yes.
Okay. And in your opinion, would it be beneficial for the city to move in this direction?
I guess I would have questions about it as well, just as far as guidance. Delinquent taxes, so real estate delinquents taxes wouldn't be until after May 1st. I know we have due dates of August 1st, November 1st, February 1st, and May 1st, but technically real estate isn't delinquent until after the May 1st deadline, which is when we kind of put them in tax title subsequently a month or two after that date anyway. I would just need guidance as far as excise, water and sewer, if they're delinquent on that. Those are 30 days generally, they're delinquent, but
So the way I read the law, there's substantial discretion permitted. So there is, by the eliminating the 12-month waiting period, it doesn't create an automatic situation. There's still the ability
because they
to.
use the term good standing as well. I think we would have to define good standing.
Council Melville.
Thank you very much, Mr. Chairman. I actually deal with this particular section of law pretty regularly in my day job with regards to municipalities and alcohol licensing specifically, but I know it carries over as the statute declares into a number of different other areas. Paragraph C is very broad that you had alluded to, and I can tell you that the conditions that can be placed on either a payment plan being enacted and the collector reporting back on that payment plan, or with the Department of Revenue would reference a certificate of good standing, which essentially states that the entity is in good standing with the Department of Revenue either through their payment plan or based on wherever they're currently at with their taxes. Also, the most important point that you make is that it's a delinquency issue. It's not necessary. We always like, the term owed taxes. Do I owe taxes? Is thrown around. It's really delinquency. You might bill somebody on the 1st, they owe taxes, but they're not delinquent until 30 days or 60 days, depending on the type of thing. So I think that this is currently how you're working. I think really what we're saying is to tighten it down, which is very common throughout all the municipalities in the Commonwealth right now. I think what you would want to, and this is just a suggestion based on you talking about guidance, and I don't want to overstep, but maybe a document or a form letter that would say that the permit applicant or the permittee going for renewal would be in good standing with the city with regards to those policies and those payments. I think that might be what we're really looking for. I could be wrong, but thank you, Mr. Chairman.
Councilor Manning Martin.
Mr. Chairman, through you to Mr. Morphus, you were very helpful to me when this came to light, so you actually the one that referred me all the information, and you were very helpful. And what I would suggest is if the council does, and hopefully I hope the council moves forward with this, many other municipalities have already enacted this, so I think maybe if you reach out to your counterparts, they may be able to give you direction on how to smoothly transition it. And again, it's more just a tool for the council to better operate. Thank you.
Yeah, I could do that.
Other committee members? Other councilors? So, Councilor Manning Martin, you're not on the committee, so I don't want to get the motion from somebody on the committee, but if a committee member would choose to advance this, the motion would be to move to advertise a change to Section 16-4 of the Code of the City of Peabody to incorporate the current language of Mass General Law, Chapter 40, Section 57.
Move, Mr. Chairman.
You heard the motion from Councilor Gould. On the motion? Seeing none, roll call.
Councilors Melville,
Yes.
O'Neill,
Yes.
Gould, Gravel,
Yes.
McGinn.
Yes.
Motion carries 5-0.
Item C on the agenda. It's a motion by Councilor Gravel to move to refer to Legal Affairs Committee the issue of utility companies marking up and defacing public and private property without notification. Councilor Gravel.
Yes, thank you, Mr. Chairman, and I think the council who saw this at its best and most prime time was Councilor Turco, because he came right up the street and had a chance to see what the artist had left, both on my lawn and flower bed and street and sidewalk. You know, when making the motion, my goal really was not so much what had happened to my house, but to not let it happen to anybody else's in the ward or in the city, because it seems to me rather unfair that without any notice, somebody comes, walks onto your property and starts spray painting, digging, or putting things into the ground, again, without any kind of notice. Now, subsequent to that, I was sent something by the city solicitor which says that there is some ordinance already in place that speaks to the requirement for notification, but I can tell you that we never received any notification. So what I'm looking for is to strengthen the ordinance to require notification with penalty if there's none to the utility company that violates, and at the same time address another issue that has come up several times on the council over the years, which is utility companies who get to come in, rip up the road, and put it back in a less than satisfactory manner, so that by the wintertime it becomes the next trench or pothole that we have to drive through. And I think in some cities and towns that I've looked at, they require curb-to-curb replacement of the road if they dig a hole, so they just can't put a patch. I think there are several examples in Peabody right now where utilities have dug up and they basically just threw a patch in with not enough fill, so that you already have a sinkhole forming. And there are places where they remove good concrete berm and fill in the space with hot top. So I think if we could have the ordinance strengthened to say that, you know, and we could ask our legal counsel to frame it in the form of the ordinance itself, but to say that no property shall be trespassed on without, or entered on it without prior notice. That's a simple thing to, you know, that they would have to enter through, I would think, the building inspector's office or the building commissioner's office, so that they have the ability to go on the property and then notify the abutters. I mean, because there are a lot of questions. So it doesn't seem to me to be too difficult to change to add into the ordinance. And if they don't do that, then they be subject to, you know, civil penalty for any defacing that they do, and that they be required to put it back as it was or better, not just the way they want to. Now, in my particular case, for those that, and again, and I think Councilor Turco was up there not only in the beginning, but in the end, he saw that they power washed and got rid of on the sidewalk and the street all the markings, and they actually got a lot of it off the grass. The mulch was never replaced, so the mulch is still orange. But at least, you know, they made an attempt to make it right. I just want to make sure that whatever they do, they make it right. They should make it right for any, it shouldn't be just a counselor, it shouldn't be anybody, it should be anybody. If they come on your property and they do something to your property, and I know they have to, and I know we can't deny it, and I certainly don't want to be the person that's denying it, but put it back the way it was and make it right, and let you know they're going to do it. And those are the only two things that I'm most concerned about. And I think while we're doing it, we might as well address that whole issue of the streets and sidewalks when they dig them up, to put those back in proper order too. I mean, why do they have the right, if they take up a concrete block sidewalk, to put back hot top. So yeah, concrete, hot top, concrete. You know, it's not right. You know, taxpayers pay good money for that stuff, and it should be done the right way, and they should, you know, take that responsibility with them. So that was what I would like to see, and I would like to have our city solicitor, or whoever's acting in that capacity right now, craft the language so that we can adopt it so that it can be enforced.
Thank you, Councilor Gravel. That email you made reference to, I was copied on it as well, so since you referred to it, I'd like to enter it into the record. Could we move to receive that?
Move receive.
There's some copies here. And Councilor Gravel, I think when you referred to this, you referred to it as an ordinance. That was probably an inadvertent reference on your part. I think what it actually is an excerpt from the cable agreement between the city and Comcast. So,
But I'd like it to be an ordinance, because it should apply to not just cable companies, electric, water utilities, gas utilities. They all have the right to enter your property, and they take full advantage of that. And it starts with their contacting DigSafe. And at the time that they make that contact, there should be a process that kicks in that notifies you that your property is going to be entered, and that you're going to have to allow them entrance. I don't deny them that at all, but that once they enter and once they deface, they have to bring it back to the way it was.
thank you. And that was understood from your initial comments. So, Councilor Turco.
Thank you, Mr. Chairman. Just briefly, Councilor Gravel, I wanted to mention that, although it's unfortunate what happened to you recently in the last 3 days, actually, I received a call from a resident on Gemma Drive, same exact issue. The markings weren't as bad as at your home, but they did destroy a large portion of her grass where they held a machine that needed to cut down a tree that was next to that utility box. And she had seen the article in the Lynn item, and she knew to reach out. So we're helping her get her lawn repaired. So it did serve a purpose. I know it was an unfortunate event, but it was great that residents are able to understand that they can address this if it happens. But thank you.
Councilor Tress?
Thank you. Even though I'm not on the committee, thank you for allowing me to speak. Councilor Gravel, I certainly support this 100%, because there's too many times that, like you said, they dig up this trench all the way down the road, and the winter comes, and it's right where the tires run, and it fills up with water. When I first got on this committee, I had to keep the hammer down on the utilities up in Brooksby Farm area for exactly that, not putting enough fill in, not coming back and refilling it, and doing the seal on the edges. There's a seal to use so the asphalt clings to it properly. And then with the cement sidewalks too. They dig them up. The utility company down here on Lowell Street, I've reached out to them numerous times, even with the DPW director, and he's helped me out with that. When they rip up the concrete, it is an ordinance. They need to put the concrete back and not the asphalt. They'll put the asphalt in and say, well, we're going to come back and redo them all at the same time. And unless you hold their hands, they don't do it. And it does. It makes it look horrible. So I'm certainly glad you've done this and took it to the extreme of making sure they, not just patch it, but do it properly. So thank you.
Councilor O'Neill.
Thank you, Mr. Chairman. I guess through you, I'd like to ask Councilor Gravel if he would consider, I get the intent of what he's trying to get at, and I agree, especially with the utilities not repairing, as Councilor Suresh just talked about, but then also just coming on the property. Would we have to have some kind of, call it non-emergency service? Because I guess I wouldn't want to impact them if they have to get in there and mark it up. Thank you.
I would agree with that, and that's why I think it's properly put it before an attorney who would absolutely think of something like that, because, of course, if there's an emergency, they got to get on, shut off the gas before the street blows up. I'm with you. This one evolved around DigSafe, and it's not. And I think the DigSafe people thought we were more angry at DigSafe, and we weren't angry at DigSafe. I wasn't angry at DigSafe. I just don't like to see anybody's property. I did see that one on Gemma, by the way, because she had sent an email to me saying she was addressing a similar thing, which I was glad you addressed. And I just, it's like a courtesy. But if we have to put it into an ordinance to make the courtesy happen, then so be it.
Councilor Gould.
Thank you, Mr. Chairman. I think Councilor Gravel is right on target with the curb-to-curb issue. If we could ever implement that, we would. You referenced that some cities and towns have that. I think that would be a wonderful thing if we can make sure that doesn't get lost in the motion. So when you do go to make that motion, Councilor Gravel, please include that language. Thank you, Mr. Chairman.
Other councilors, I think we also, just to add to this, I mentioned when you first brought this up, some things that have happened downtown periodically, and I think we've actually done it to ourselves in some cases. For example, with the International Festival, marking the locations of the booths, spray painted on bricks. That's for a one-day event. That's going to be there for a significant period of time until it wears off. So we should sensitize our own DPS and others that are involved with activities in various areas that when we're doing things on a temporary basis like that we need to be mindful of this as well. I'm sorry. So I'm being told that that's not the DPS. The DPS doesn't.
I was just going to say that during election time, the Board of Registrars does mark the 150-foot lines at the polling precincts, and we'll spray a little orange marker on the sidewalk. So it fades away, but that's how we mark them up.
Yeah, and I don't want to be too over the top on this, but if there's an option of putting a marker on the street versus brickwork that we've paid substantial sum of money for that hardscape, I think there's a judgment call that can be made there to put the marking in the street, not on the hardscape. So, Councilor Gravel, would you? The other comment I'd ask is perhaps to include in your motion that whatever the research that's being done by the solicitor to make sure that we're not creating a redundancy here. That if there's already some existing Mass General law that provides this protection to property owners and or ordinances that we if it's a city ordinance that we strengthen it, to your point, or if it's a existing state law that we actually move to enforce it.
So, to me, the motion would be to refer to the city solicitor the request for an ordinance to require any utility or other service coming onto a residence, that a notification be provided in advance of them entering the property, and that if any markings or defacing of the property were to occur, that they are required to return it to its original condition or better, and that if any public street involved in this is defaced or changed, that it be returned. I'd like to get that curb to curb in there, because I think that'll help us with the pothole issues. And that obviously, if there's to include an emergency provision, that they have the right to do it without notification in case of emergency, and to ensure that we're not making anything redundant, that current laws are being observed. We're trying to strengthen and have enforcement. That's.
Councilors, you've heard the motion. On the motion, seeing none, roll call.
Councilors Melville,
Yes.
O'Neill,
Yes.
Gould.
Yes.
Gravel.
Yes.
McGinn.
Yes.
Motion carries 5-0.
Take a motion to adjourn. We are adjourned.